In Utah, 18-year-old Megan Grunwald is taking the stand in her murder trial, testifying that she was caught in a nightmare she didn't think she would survive. This all happened when she accompanied her 27-year-old boyfriend on a deadly crime spree. That January of 2014 police chase caught here on dash cam. It ended with one officer dead, another clinging to life. Grunwald explained she followed her boyfriend's orders out of fear and not because she loved him. She described how her boyfriend threatened to kill her and her entire family if she did not drive the getaway car, during which time those two police officers were shot. Joining us now, Tom Caniff, a criminal defense attorney. Wendy Patrick is a trial attorney and a veteran prosecutor. She is 18 years old. He was 27. He lied to her about his age, and he turned out to be the boyfriend from hell. Is a jury going to have some sympathy for her?
You know, the prosecutor says this is Bonnie and Clyde. This young woman was driving the getaway car. Now, of course, she's on the stand, and we heard some very emotional testimony yesterday. But actions speak louder than words, is the prosecutor's argument. And it's largely corroborated by what she did that day. You know, the defense says it's, you know, we often say it's not like you have a gun to your head, but that's the defense in this case, is that she did. So it all depends on whether or not they believe what she said in determining whether she had some kind of an excuse, a mitigant for her behavior.
It's pretty unusual for any criminal defendant to testify in their own defense, and her attorneys must be pretty confident that the jury is going to like what they hear from this 18-year-old woman.
I think they are. You know, it's interesting what the defense is doing, John. They're really fighting a two-front war. On the one hand, they're saying that, look, their client had no idea that this officer's tragic death was about to occur. She didn't participate in this crime in any way. I mean, you know, you could say, yeah, she drove the getaway car, but that assumes that she knew that there was going to be a murder that was going to take place, you know, when she originally got behind the wheel. The second thing they're doing here, and it's interesting because under Utah law, it really gives the defense a lot of room to roam. They're arguing what's known as, what Utah calls a compulsion defense. Other states call it duress or necessity, saying that, look, even if you find our client would otherwise be legally culpable, you need to excuse her conduct because her conduct wasn't her own. It was carried out under coercive threats of imminent harm to her and or her family members. In this case, you really have both, because not only is the boyfriend allegedly holding a gun to her head, but he's also telling her that, look, if you don't at least remain complicit in what's going on here, not only am I going to hurt you, but I'm going to hurt your family too. And that's a defense in Utah.
But, John, here's the problem with that argument, is the length of time that this went on belies the fact that she was under some sort of compulsion or duress. It just went on for too long, is what the prosecutor's arguing. This young lady even flagged down a car that they ended up carjacking. So that is one of the factors that weighs against her testimony.
All right. Stick with us, legal panel, if you would. We want to get your thoughts on this. A woman wants $5 million from United Airlines. Why? Because she bought the Wi-Fi and it wouldn't work. Does she have a case? Back with that in a moment. All right, so United Airlines is asking to dismiss a $5 million class action lawsuit. The suit alleges United tricks consumers into buying in-flight DirecTV and Wi-Fi services that are inoperable during international or over-water flights. A woman says she paid for the service but was only able to use the Wi-Fi for about 10 minutes of a 4-hour trip. Now she wants money. Does she have a case? We are back with Tom Caniff and Wendy Patrick. $7.99 she says she paid, and she wants $5 million from the airline. Does she have a case?
Well, there's a lot of emotional appeal to this case because it's about the essentials, right? Food, water, Wi-Fi. Lots of people don't even want to get on a plane because they're worried they're not going to be able to log on. But technically, the devil's in the details. She should have read the fine print, which supposedly, according to United, says they don't offer that unless you're in the U.S.
So why not just go for her $7.99 back, Tom?
Because, John, this case demonstrates why the only industry that may be more loathed than the airline industry is the legal industry, particularly plaintiffs' lawyers who put together these absurd class action lawsuits. No one makes money off this case, certainly not this plaintiff, other than the lawyers who bring these class actions. If United doesn't prevail on this motion to dismiss, There will be a settlement. The lawyers are going to collect a lot of money, and the poor saps who couldn't, God forbid, get there keeping up with the Kardashians on their transatlantic trip to Paris are going to be lucky if they get a $2 coupon in the mail for a rebate off their next in-flight movie. I mean, that's the reality.
The airline says it's on the screen that it's not going to work if you're over water, and she was flying between New Jersey and Puerto Rico.
That's what it all comes back down. The issue is, did the airlines intentionally engage in deception? And I think it's very doubtful that they did.
But you know what? I'll tell you, everything we want to do online says agree or disagree, so we've got to click that without reading the fine print. Everybody does it. That's why I said that it has a lot of emotional
Nobody reads
appeal.
the fine print. We know that.
Logically, that's true, but emotionally, it's got a lot of appeal, this lawsuit.
We'll see what the court...
I'm going to join if she wins.
You'll get your coupon.
We'll see what the court decides. Wendy Patrick, Tom Kniff. Thank you both.
Thank you.
Jenna.
Well, John, what